Module number 6. Have a few more lectures. We're at 6, so we have 1, 2, 3, 4 more. 4 more lectures before we dedicate, actually 2 more, and then we begin dedicating our time to just cases. The last 2 lectures are more informational. And then it's just working on what is essentially, if this was a regular college class, the second half is basically working on your final, even though it's not really a final, but you know, that the closest thing we have to a final is the cases. So we're getting there soon. This week, we're talking about obtaining evidence. Getting evidence from a service provider will be our first place. A preservation order is a request to a service provider to retain records relating to a suspect outlined in the U.S. Code. There's a little section that says, number 1, in general, a provider of wire or electronic communication services or a remote computing service, upon the request of a governmental entity, shall take all necessary steps to preserve records and other evidence in its possession, pending the issuance of a court order or other process. And number 2, period of retention. Records referred to in paragraph 1 shall be retained for a period of 90 days, which shall be extended for an additional 90-day period upon a renewed request by the governmental entity. Service providers could contact the suspect to let them know they're being investigated, but investigators are more likely to ask a judge to request that the service provider not inform the suspect in the subpoena. According to the U.S. DOJ, an investigator should secure the crime scene, ensure the safety of those around, and protect potential evidence, from the tiny micro SD cards hidden in a cubby, hidden in the corner, to volatile memory in computers, to any remote wipe functions on cell phones, any hidden devices in the walls, in the ceilings, in the attics, and maintain battery life on any of those evidences. An examiner should always photograph and document everything found at the crime scene, such as the connection between devices, like was a device connected by Ethernet? Were there USBs? How many USB cables? What were they connected to? Were they USB 2, USB 3, whatever? Document both digital related and conventional devices, such as the cables, the adapters, the boxes from articles and manuals, any post-it notes, because they may have passwords, any USB drives hiding in jewelry, or even masked as a toy. You have to be really meticulous in the crime scene. Finding incriminating evidence on a device is worthless if standard operating procedure is not followed. These protocols must be followed from the crime scene to the forensics lab to the courtroom. Defense counsel often spends much of its time questioning the actions taken by investigators instead of focusing on the actual evidence. So think about that. You as an investigator may be receiving a computer to do work on. Like the cases like the case last week, the case this week, the quote unquote final, you are receiving evidence that was seized, but remember that the work that you're doing if this was going to a court, the defense counsel would often spend time questioning every little thing you did instead of focusing on the actual evidence. This is why we have to be very meticulous in what we do. So as mentioned before, in the crime scene, investigators should take copious notes about any equipment found, photographing everything, including screenshots. All media devices should be tagged and recorded. Your field kit should provide you the equipment necessary to acquire all the evidence. And it doesn't go without saying that all evidence should be properly documented and secured. Your chain of custody form. The assumption must always be that evidence acquired will end up in court. Therefore, everything must be handled in accordance with the law, legally obtained through court order, through a subpoena, through a search warrant, or with consent of the owner. As mentioned before, the defense attorneys will examine the chain of custody and try to find mistakes and render evidence inadmissible. For example, when making 2 copies of a suspect's drive, there are now multiple hard drives that must be accounted for on the chain of custody form. Every investigator's computer worksheet should have as much detail about the system as possible, like who was the suspect and or custodian, the case number, the date, the location, who is the investigator, the make and model, the serial number, the CPU, the RAM, the BIOS version, the BIOS boot sequence, the OS, any drives, BIOS system time and date, the actual time and date, what type of ports. Everything should be photographed and added to the investigator's report. Same with things like the hard drive. Everything from the things prior, including things like the serial number, the make, model, the drive type, the capacity. When we're talking about hard drives, it should also list the forensic acquisition. Was this made by an image or was this made by a clone? What hardware, software was used, along with all the details about the destination drive. Any error messages that happened during the acquisition should also be noted, and whether the process needed to be restarted. There are some tools that you could use to help you document an investigation that I listed in the lecture notes. But as always, things change. So don't just think these will always be up and always work. Always test, always verify, always ensure you have everything you need before you go into a crime scene. Now, with writing reports, the time zone matters. Investigators must note the current time and source of current time. All examined systems must be noted and compared to the investigator's time. The easiest thing is to use UTC for yourself as the investigator, because UTC doesn't change. It is the same year round. So when you're investigating a system and you're writing your timeline, go with UTC. The report should be technically precise, yet also need to be comprehensive so that somebody with limited technical knowledge can understand the investigator's actions and report findings. If there are any acronyms or technical terms, those should all be explained. No ambiguity should exist in the report. Use graphical representation for data can help remove ambiguity, like a graphical timeline of events, graphic of networked friends on a Facebook network, maps indicating any geotag metadata. Ultimately, your report should be detailed enough for someone to use it to recreate the same analysis and retrieve the same results. A prudent investigation that produces facts for the case will have nothing to worry about. It is the duty of the investigator to be fair to both the prosecution and the defense. So this next section is basically what you need for the second half of the course. So if you are writing things down, if you are bookmarking, if you are, well, however you're keeping track of all this stuff, lecture number 6, but 3/4 of the way down, there's a section called structuring the report. That's what you need to structure out your reports that you will be making for the 6 big cases in the second half of the semester. So here we go. What you need is a cover page that has the report title, the author, the department organization, investigation number, report date, signature, and dates for all involved in the investigation. You have the table of contents. That way it assists attorneys and any expert witnesses. You have the executive summary, a synopsis of the purpose of the investigation and the investigator's major findings. Any work done by more than law enforcement agency should be included and clearly outlined in the report. There should be a biography, a brief biography of the investigator, highlighting all relevant experience, such as college degrees, certifications, digital forensics training classes completed, hours of training, detailed investigative and professional experience. This section should explain why the investigator was suitable expert to conduct an investigation and produce reliable findings related to the case. We have an optional section, which is the purpose of the investigation. The report writer may have explained the reason for conducting the investigation in the executive summary. This section could be used to explain the reason for the investigation and the scope of the warrant. The non-optional methodology, explaining the science behind the examination, the approach the examiner took with the rationale for the choice of hardware and software used. You can reference standard practices like the DOJ or NIST. You have the electronic media analyzed, detailed description of the media examined, how the storage media related to other media examined, objects related to the suspect, all dates and times detailed and clearly outlined for every step taken in the investigation. You have the report findings. It is important for the investigator to state facts and be careful about interpretations, which is for the attorneys and the jury to decide. For example, it is improper to write, John Doe downloaded thousands of images of children being abused. A proper finding is an analysis was performed on the hard disk drive removed from the Dell computer model E6400, service tag 4X39P5. This computer was seized from the residence of John Doe, 123 River Road, Sterling City, New York. A total of 578,000 images of children were downloaded to this computer. John Doe noted in his statement to police, dated July 27, 2020, that he was the only user of that computer at the residence. During the analysis, it was discovered from an analysis of Windows Registry that only one user was set up on that computer. The examiner also discovered a login and password on this Dell computer. You see the difference between the two? One made an interpretation, the other one did not. It just stated facts. Three more sections that should be there are the investigation details connected to the case. Any notes supporting evidence to the investigation that is not digital, like statements from the suspect and witnesses. The exhibit or appendices. Photos of seized objects, screenshots from the computer screen, any tagged photos, printed emails, and other files of interest. Appendices can include forms like the evidence list and the search warrant. Lastly is the glossary. Placing a comprehensive glossary is a good practice as it will diminish any arguments of inequality. Defense counsels often argue they were at a disadvantage because of the lack of resources available to their investigation compared to those of law enforcement. Any questions? I know I have one more section, but just want to make sure to give you guys the floor real quick for the structuring the report. Okay. Expert witness. This will be the topic of your work this week. An expert witness can create an investigative report or review the findings of a report and interpret those findings based on specialized education, training, and knowledge. They're usually hired by the defense or the prosecuting attorney to be an advisor and be called upon during a trial to discredit or refute the report findings, draw out the importance of incriminating evidence highlighted in the report. In a trial, expert witnesses educate the jury. Any expert witness called to testify will most certainly be cross-examined. The role of the expert witness at trial is described in the Federal Rules of Evidence, which is A, in general, not automatically objectionable. An opinion is not objectionable just because it embraces an ultimate issue. And B, exception. In a criminal case, expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. As stated, the goal of the expert witness is to educate the jury and break down complex concepts into meaningful information, such as using metaphors or other analogies to aid with comprehension. The expert is also there to persuade while weaving in important concepts that can help. The expert witness should aim to imprint core concepts into the minds of the jurors through repetition of these concepts. In most cases, the expert witness is required to provide a written report. Unless otherwise stipulated by or ordered by the court. The expert witness has to have a prepared and signed report. It has to have the complete statement of all opinions the witness will express and the basis and reasons for them, the facts or data considered by the witness informing those opinions, any exhibits that will be used or to summarize or support those opinions, the witness's qualifications, including a list of publications, a list of all other cases in which during the previous 4 years the witness testified as an expert at a trial or by deposition, and a statement of the compensation to be paid for the study and testimony in the case. The expert witness should ensure that they are up to date and has refreshed their memory about the document in question. If you will be acting as an expert witness, the client's attorney will help you prepare for your expert testimony. An expert witness may be a portfolio of events and props to the court to help examine concepts or explain concepts cleared with the attorney beforehand. It's perfectly acceptable to bring a binder of well-organized notes to the trial and refer to when questions are asked. There's 4 other notes that I would like to point out. An expert witness can be asked hypothetical questions. When answering these type of questions, the answer must be rooted in facts. An expert should resist going beyond answering the question and not volunteer additional information. The expert should resist being pulled out of the realm of expertise, which could be a ploy by the defense to discredit the expertise and make him look uncomfortable and less confident. The expert should always be courteous to everyone in the court, especially with the court reporter and the judge. Never talk over someone else speaking in the courtroom, or the court reporter will reprimand you. Don't forget to address the judge as your honor, not miss or ma'am. When answering questions, be clear about who did what and when. Always avoid qualifying words such as probably. Have the conviction to say, I don't know, that is outside my area of expertise. When summarizing key concepts, be sure to include important facts derived from the evidence. Be clear about units of measurement. For example, 8 gigabytes of RAM. Pay particular attention to time zones, which defense attorneys will consistently question. And speaking of questions, any questions on this lecture? Okay. This week, you are to watch 3 videos. You're going to watch 3 expert witness videos. I gave you this first one that you could get started with. Just find them on YouTube. And you write a report on things that you learned by watching these expert witnesses at work. That is your first thing to do. Your second is case number 2. You have the story. There are quite a number of files to look through. And there are 31 questions to answer. Like last time, don't start the quiz until you have them all. You're not going to get a surprise question in this list, or when you actually hit the exam, you're not going to get any extra questions. It's those exact ones. You are always encouraged to work together, to utilize Discord to chat within one another, because these cases are getting bigger every week, and no one person should do this all on their own. I do not encourage you to work by yourself. So, watch 3 digital forensic expert witnesses in a trial. This could be your first one, so you'll have to find 2 more and write on what you found, what you learned by watching these people work. And then solve a case that has 31 questions for you to answer. So I will stop the recording.